Hello and welcome. Today we're doing something new in plain language. We're calling it the Plain Language Wisdom Panel. We are bringing together a large panel of plain legal language experts from different states across the country. Each of the panelists has years of experience with plain legal language in court and/or self-help settings. We call them a wisdom panel because they were with their agency when their plain language initiative began. That means they have seen what has worked well and what they might do differently if they were starting their plain language journey today. This is the first time these speakers are coming together as a group to discuss their experiences. Their goal is to provide information that may support plain language efforts at other courts and agencies. For panelists' email information, please contact end@transcend.net. Now, allow me to introduce you to our facilitator. Judge Fern Fisher, former Deputy Chief Administrative Judge for New York City Courts and former Director of New York State Courts Access to Justice Program. And our panelists, in alphabetical order: Laurie Garber, Northwest Justice Project Attorney and point person for Washington State's Plain Language Initiative; Deanna Glick, California Judicial Council Attorney and Language Access, Hot Docs, and Spanish language expert; Cristina Llop, Contract Attorney for the California Judicial Council and the National Center for States Court and Language Access and Spanish experts; Jennifer Simmons, North Carolina Access to Justice Attorney and Liaison to the North Carolina Courts for e-filing and plain language projects; Penny Wagner, in charge of forms, training, and self-help for the Colorado courts, including a multi-year plain language training model. This video is produced under this Creative Commons license. Attribution is required, adaptation is not allowed, and it may not be used for any commercial purpose. And now, our panel facilitator, Judge Fern Fisher.
Welcome, everyone, and I want to thank our participants today on the panel, and I'm looking forward to a really robust conversation about plain language. So, we know that the justice system is facing many challenges, but one of them is how we communicate with our users and our stakeholders. It's all the more important because of the diverse populations that are using our court systems and our legal agencies and organizations with different language abilities, different reading levels, and let's not even talk about the fact that our attention spans have reduced since the pandemic. So plain language and the use of plain language is extremely important right now. So I think this is a very timely discussion, and I know that all of you have opinions about plain language and how to get the job done. And today, feel free to jump in and offer whatever opinions you like. But I'd like to start off with a question for each of you. If your jurisdiction was able to implement a perfect plain language program, what would it look like, Penny?
Great question. Based upon what we have done so far in Colorado, I would start at the top down, and I would ask for a Chief Justice directive identifying a strategic plan for the conversation and the implementation of all the court forms and documents to all be in plain language. And the second thing I would do is it would be fabulous to have total buy-in from all of our state court judges. That has been a challenge for us, and it would be extremely helpful. The other thing I would do is I would ask that we have plain language as a part of our required court training curriculum. We talk about it in pods across the state and in different groups, but collectively make it actually part of our training, and that we are able to achieve the conversion of all of our existing plain language, of all of our existing state court forms into plain language.
So Penny, and I know the answer to this question. It might be helpful to our viewers to know, is Colorado a unified court system?
Yes, it is.
Great. Deanna, do you want to answer the question?
Certainly. So I am with the Judicial Council of California, and we are also a unified court system. And, in thinking about my answer to this question of a perfect system, I think we produce content that needs to be, it needs to be plain, obviously, in order to reach folks, but it also needs to be able to be translated into multiple languages. It needs to be made accessible to people with visual impairments. And so when I think about what might be a perfect system, I'm thinking about plain language as being sort of a threshold for all of those other ways that we need to create content. And I think, in my ideal world, we would have an embedded in-house team that really brings together people from a variety of disciplines, including content editors, content writers, some web UX experts, some visual designers, attorneys. They have to be there. And I would love to see that group really become generalists and be able to work in all areas of content that we produce. And I would also really love to see them build a step in of testing to make sure that the people who are needing to access these materials can do so, and that we get the feedback from the public consistently, in terms of the development work that we do. So that would be a perfect system for me.
Thank you, Cristina.
Well, I kind of sort of want to second just what Peggy and Deanna said, because that's essentially what I think would be key. One of the things that Deanna and I do a lot of work for California, although I also work for, do some work for the National Center for State Courts. So I've been involved in other jurisdictions. But one of the things that I know I've talked with Deanna about, and this is specific to forms, is that when forms get sent out for public comment, which is the California process, the reality is that the people who really are using those forms don't have the time or are too overwhelmed to provide comment or do it in a vacuum. And I would love some sort of a system of sort of assigning or having a group of, let's say, 50 self-help center providers that each, maybe a group of 5 or 10 of them take each form cycle on and actually test those forms out, the proposed forms with users for themselves and with the users, with the self-help center customers, as we call them. Because we don't really realize what's wrong with these forms or where people are getting stuck until it's too late, right? The forms have already been approved by all the committees. And so trying to catch as much of that and engage as many of the people, the ultimate users of the forms, the courts, the self-help centers, and the actual litigants beforehand, I think would be really helpful.
Okay, Laurie?
Well, I just really want to, second everything that's already been said. That sounds like some major improvements would have been made already if we could adopt all that. I'm working in Washington State and from the legal aid side, not the courts system. And I think, if we get to dream big, I would step back even one more step and have more plain language coming out of the legislature. We've had a lot of law reform initiatives in the area of family law over the last few years in Washington State. And some of what's come out of that has been so obtuse that, no amount of plain language can make a really complicated process clear. And so bringing the concepts of plain language and clear communication in even one step back into the legislative realm would be incredibly helpful for us. But even just some real basics about having fully staffed court forms committees where there's fully staffed centralized support out of our administrative office of the courts. We've come a long way in Washington in adding additional staff, but they're always stretched too thin, and there needs to be a real recognition that court forms are an important public service that is the role of the courts to provide. And so it needs to be fully staffed, and the staff needs to be trained. It needs to be part of their onboarding to be trained in plain language and ongoing training. That would go a long way. But I love the idea of bringing in other voices into the court form review process. We did a little bit of that recently in Washington with our protection order form revision that we just completed. And it was the first forms committee that I'd been on in 15 years that had non-lawyer or, multiple non-lawyers on it. And it was really wonderful and made a difference in the language that we used and the way that we conveyed concepts in the forums. And so finding a way that honors and respects people's time, because it's a huge time commitment to participate in these forums committee, but brings in necessary voices, would really, I think, help make it a better system. And I think finally that also recognizing that the way that we present our forms on the public websites and how people find the forms is incredibly important, because you can have a beautiful, clear, plain language form, but if no one knows where to get it or how to find it, it's not going to help. And so bringing in, having better, website communication and easier ways for people to find our forms would really help.
Jennifer.
Yeah, thank you so much. If I had a magic wand to implement the perfect plain language program here in North Carolina, I think I would be incorporating a lot of the suggestions that have already been made by the prior panelists here. Those are really wonderful, and I appreciate how y'all articulated them. When I heard this question, my first thought was to think about the value of procedural justice, which, really focuses on helping users of the court system feel that the justice system has treated them fairly and that they had a meaningful chance for their side of the story to be heard, which, the goal, of course, is to lead to increased respect for the results that the court system produces, as well as to the authority of the court overall, no matter what the actual outcome of that interaction is. And so I think one hears about this concept most often thinking about policing practices, but I really think it applies very nicely to the concept of interactions with the justice system much more broadly, including through the court system. And so thinking about plain language with that in mind, of how can I help users feel like they're being treated more fairly as a matter of procedure, as a matter of understanding what's happening to them, because of course, so many court users are not there by choice. I thought about user testing. I thought about actually asking the court users themselves how they would like to be spoken to, presenting them with multiple options and seeing which one makes the most sense to them. Even when we are trying to write with them in mind. As a lawyer, I'm well aware that my best efforts at plain language can almost always be improved. In North Carolina, at least, I would be really excited for our court system to extend the reach of its plain language services. We do not necessarily have our court forms developed today with plain language in mind. And so certainly a broader reach here would really go a long way. We do have some ways that we're working around that here within our state. And one of those is something I'm sure I'll talk about more later, but we have set up document generation systems that are reliable and well tested, which can be a way around court forms that are not particularly plain language friendly, because you can ask questions in really plain language and then use the answers that someone gives to those questions to populate the court forms, which is a way to provide access when just handing someone a more complex form isn't going to help them fill it out in a way that's meaningful or even tells their story accurately. And while that is not the ultimate solution because it falls short of full participation, if the forms that are printed out at the end of that still, it's hard to understand how it's filled out, but if it's the information you provided, it's at least increases the likelihood that you feel like your side of the story is being told clearly. And then I think the very last thing I said would really relate to something I heard earlier, which is better training for our staff, really at all levels. When I think about plain language, there is certainly written plain language that's really important, but oral plain language is also really important for folks who are not represented by attorneys. And so I think the ability of everyone from judges to DAs to clerks to be able to speak in a way that's more comprehensible to your average court user, And also I would add in increased tolerance for people when they don't understand. I think folks get busy, folks are time pressed. There's never enough time to get through everything that staff needs to do in a day. And so when people don't understand and try to follow up with questions, or maybe just don't even follow directions that they didn't understand from the beginning, we sometimes get, unfortunately, a little frustrated in our court system. And so I think increasing tolerance and helping folks remember that court users aren't necessarily being obtuse when they don't understand or express confusion.
So I know that in a sense, I'm, as they say, preaching to the choir here, that we are pretty much all on the same page, but that I think we all agree that clear communication using plain language is essential to to fairness and to have trust and confidence in the justice system by its users. And so that's why today's discussion is so important. So when I ask you the next question, we're going to follow up with talking about what happened that was good and the challenges that you had, but how close on a scale of 1 to 5, with 5 being the highest, is your jurisdiction to achieving a perfect plain language program? And I understand we don't want to be critical, but just to give an idea of where you think your jurisdiction's at. Penny?
I would say in Colorado, I feel really comfortable in giving us a 2.5. We're kind of halfway there. We've gotten approval from the Supreme Court to move forward. That's the blessing. So all of the things that we do from this point forward will be done in plain language and requirement, converting all of our existing forms that are in legalese. And I love some of the concepts that have been talked about, not only in writing, but verbally, having those trainings as well. We do have a few judges that are very proactive in that regard. So, really hope to build on that. Like I said, we've got the approval and the blessing from our Supreme Court. We've got a style guide that we've developed that is going to be used statewide. We only have one person staffing our forms, and hope to expand on that. But I think we've got our house built, the framework, and now we're just starting, focusing on filling it in and building from there. We do have a standing committee, an Access to Justice standing committee, and a part of that is a forms subcommittee that has given us tremendous momentum in moving things forward. So we take things to the forms committee, new forms, whatever changes we want to make, get the blessing of our standing committee that is chaired by one of our Supreme Court justices, and then that is moved right up to the Supreme Court. We've bypassed a lot of the other requirements and hurdles and blocks that we have faced in the past. So we now have kind of that gateway. Now we just need to build upon it.
Great, thank you. Deanna?
Well,
1 to 5.
I'm gonna phone my friend Cristina over here so that we can give the joint
do a consultation.
A joint response on California. I kind of feel like a 2.5 might be appropriate for California as well. I feel like we definitely have commitment, we have interest, we have lots of people who really want to render things in plain language, kind of at all levels. And I think, because my perfect vision is sort of this great team, I don't know how much we've been able to make progress towards that, but we do have a lot of people working on plain language and the forms and our content across the agency. And I don't know, Cristina, what your thoughts might be.
I completely agree. I was going to say, like, in some ways it's opposite of, I don't know about opposite, but we don't have what Peggy talked about that they have, which is the underlying structure, like standards and things like that.
Yeah.
A lot of people who believe in it, leaders who believe in it, courts at the local court level that believe in it and are supportive of it, but we don't yet have the structures or we haven't institutionalized it or systematized it in a way that we can count on, I think, is what I would say.
Laurie, where's Washington?
it's really hard to put a number on it. In some
Are you
ways,
halfway? If you can't give a number, where do you think?
yeah, I think halfway, and in some areas I feel like we're above a 2.5, and in others we're just getting there, because I feel like we've taken it sort of subject area by subject area, and there's some great leadership and a recognition from the top and from our Supreme Court and from administration of how important it is, but we absolutely lack a structure for it or standards, and that I think holds us back a bit. But what's encouraging is that is the commitment that as things change and as we're revisiting new forms and as different subject areas are tackled, that plain language is a stated primary goal that everyone's on board with, and so that's really encouraging.
Jennifer, what's happening in North Carolina?
Well,
Are
I'll
you-
demur from the quantitative response if you'll accept that, but I'll say that you can probably
I'm a
draw-
judge, I don't know, but go ahead.
I thought it was a little dicey trying to pass on the question, but I'll tell you this. I'm from our Access to Justice Commission, and I work in close partnership with the court systems, but I'm not a court staffer. I'm not part of the court system at all. And we are here within our state. There's not someone on the court staff, much less multiple someones who have this as a primary part of their job, or even truly like focusing on individuals who are coming to court without attorney representation at all. It's something people take into consideration. I don't think anyone's opposed to the concept, but as with any system that's shorter on resources than everyone would like to be, in many ways, sometimes tasks are dictated by the hottest fire on the desk. And so I do definitely think we have a good way to go. I think what we're trying to do here in North Carolina is, as we move forward with new initiatives, new services, is trying to get it right on those areas. And then certainly speaking from the Access to Justice Commissions, we're always looking for opportunities when something's being revisited to go ahead and try to get it right at that time. And certainly we hope to be able to do more as time permits and as the court system has resources to spare to work with us to pull that together.
So Jennifer, I'm going to start with you, since I'm going to work my way back and give everybody a chance to go first. What have been the challenges that North Carolina has faced getting to the current status of your plain language efforts?
Yeah.
Top two, top three.
Of course, no problem, because of course you could talk a long time about this, couldn't you? Why don't I say just a moment about what it is we've specifically really targeted so far. Working from the Access to Justice Commission's perspective, we've really been targeting these document generation services. We're in the process of redoing our court systems technology in creating online filing and an e-court system. And so the company that we're working with also had document generation services, and that was really our effort, which is a true, I think, a really genuinely access to justice initiative. As I said earlier, I think that's a way for folks that might struggle to fill out even or find, as someone pointed out, I think that's a really great point, even finding the right forms, knowing what you need, much less filling them out correctly to express your situation on the ground is a struggle. And so what we've done, is actually use the plain language and the document generation system to try to help folks express their facts on the ground as clearly as possible. But even getting here, staff resources is certainly the number one problem. I would love to get dedicated court staff. My low-hanging fruit ask would be really for that SRL focus, folks who can't access attorneys. The truth is, I think here in North Carolina, a lot of our forms, a lot of our processes are designed with attorney users in mind and not so much with court users. And I think we lack data. Our old technology system did not have a way to generate statistics about how many cases were represented and unrepresented. And I think that lack of quantitative information has been a barrier to recognizing how significant of a problem this is to justify additional resources. I would also add it's been my experience that lawyers are not always, I had mentioned it earlier, the best at this, and I'm speaking as an attorney who's done what I thought was a really good job at it to begin with, and then with talking to plain language experts, realizing that there was still so much room to improve that. And in fact, I was looking at another state's self-help website recently and asked them who they had used as their consultant, and they said they just had non-lawyers on staff writing their content. And I was like, oh, right, non-lawyers are better at this part of the job than I am. So I think that's one thing I would certainly say. The legal jargon has been a real challenge, focusing on legal standards. We really have had a lot of concern about whether plain language is going to create issues with insufficient findings of fact or conclusions of law. If the pleadings, get rid of some of the phrasing that's been used in case law over time, or might be pulled directly from the statute. So I think interpreting legal jargon has been a real challenge for systematized processes here. And then the last thing I'll mention is just we've really struggled with the value of, from the institutional perspective, about they're both important values, but reliability on the one hand versus comprehensibility on the other hand. So one example was we got a recommendation at the end of the document generation. We spit out, in addition to the document, some instructions for what folks should do with those forms. And our template is an 8.5 by 11 page piece of paper with letterhead at the top, and it's written in paragraphs. And we put some bullets in, and we try to use short paragraphs. But the recommendation was to turn that into a pamphlet that would be easier to read, a little less intimidating to your average user. But the response and the concern was that, boy, does a pamphlet really look as reliable as this document does? And so we ended up not adopting the pamphlet simply because the court wanted to make sure, I'll use the word dignified, I think would be a fair assessment. They wanted to make sure that it reflected the institutional dignity and the importance that it should carry with it. So that struggle has really been something we being the folks that think a lot about plain language, haven't necessarily won that struggle yet.
So, this is a good follow-up question, and I'm going to go to others to talk about their challenges, but to follow up on one of the challenges that you mentioned, and one of the things that you said about the perfect world of plain language. Have any of the other jurisdictions had trouble with getting the court to change their focus to look at being more responsive to users who are not attorneys, as opposed to attorneys, to be more tolerant and I would call it empathetic to the plight of unrepresented litigants? I will not name the jurisdiction that just did this because I'm not pointing fingers, but just recently a jurisdiction that I'm familiar with redid their forms. Because there was a major change in the law. The forms are not only in plain language, but they did the forms for attorneys only. So all the lines had signatures for attorneys, the back had a spot for an attorney, so that if you were unrepresented, you'd have to go through the form and cross out all the information that says attorney's name, attorney's address, attorney's phone number, I affirm as an attorney. Anybody else, any other jurisdiction having the problem getting your jurisdiction to embrace the need to be user-friendly for people who are not lawyers? And how does that affect your plain language efforts?
I can just say here, but this is quite a while ago, so this is before Deanna's time with the Judicial Council. I remember, and Maria Minlin might remember this because she was involved in this effort when California first started doing plain language forms. They looked very differently than they do now, and I mean than the regular forms that they were using before. And so there were a lot of comments around the forms looking cartoonish. Back to Jennifer's point about the official, the dignity of the form.
Mm-hmm.
They look, there was some introduction of some icons for like the firearm prohibition or of the service with a mailbox or whatever. And there was a lot of resistance initially around like, this doesn't seem serious. This can't be coming from the court. But eventually, I mean, I think the reality was 90% of litigants are in family, you know, this all started in family law, which I think is pretty common probably for a lot of us, right? And the reality was 90+% of litigants were self-represented, and self-help centers were really sort of building up and getting across to their own individual judges. So I think it happened both top down and bottom up of like, this is what we need. But it, you know, I'm talking 20, 25 years ago. So, you know, we're past that point and there is a future that's more hopeful, but I remember those days.
Well, I'm happy to hear that California's gotten to the point where they're past that. You know, one of the forms I looked at even had the word aforementioned in it, and I just shuddered when I saw that word. And it was jumbled, and it was no white space, and you know. So Penny, let's go to you. Is Colorado embracing being user-friendly, and what are the other challenges that you've had getting to the point you're at now?
So taking your second question first, in regards to signatures, we have statutory, you know, some statutory statutes, basically, obviously, that direct us for signatures. And we have added, so we've got space on all of our forms, both for parties, you know, identifying the type of the party, you know, plaintiff, defendant, and also for attorneys. And in Colorado, we have 3 types of signature requirements. We have, let's see, now I'll try to embarrass myself and not remember what they are. We have what we call verification and notarization, and then just a plain signature. We went through it, it coincided with our effort to start doing plain language in getting some of the statutes changed that require notaries on our forms, notary signatures. So we got 99% of that eliminated. So most of our forms do not require notaries. There are very few that are, and we're working on getting those changed. But we have very clear distinctions on our forms on what types of signatures we have and who, you know, who signs them. You know, now that we've got the momentum and we've got the permission to do all of this, to get it going, it would be great if we had more staff to, you know, to be designated to just work on our plain language.
Let me follow up on the point about staffing. And I think, you know, there's probably not one jurisdiction that doesn't require more staffing to do a perfect plain language program. So I think that's a given. None of us have enough resources. But if there were enough resources to hire staff, do we have the right people available to hire that can do plain language? Has anybody had problems locating and hiring or identifying people who actually are trained in plain language, who really can do the job the way it should be done? Now, for example, another jurisdiction that I'm aware of just hired a plain language person to coordinate that state's efforts, but the person isn't trained in plain language and has to actually take the Simon Fraser course in order to do it. As I said, I'm not pointing fingers, I'm not identifying the jurisdiction, but is anybody else having that problem with finding the right people to actually do the forms?
Well, Judge Fisher, I'll just say it might be obvious from my earlier comments, but we're not actually in the process of hiring someone to do plain language. But I have done some research online to look for accessible training on plain language concepts that would be relatively easy and bite-sized for our own commission staff to use as we're developing materials and other ways that we communicate with the public about a wide variety of topics. And it's tricky to find good training that's more than just a page of guidelines, but is actually like exercises and more interactive, but it isn't like a paid, full, very intensive course. So we're still looking for that sweet spot, honestly.
There's one in Canada. Nothing in the United States, actually. Yes, that is certainly. Would it be helpful? And I know that the Center for Court Center for Courts has done some training, which I think is excellent, is if that was offered more frequently, would that help a jurisdiction like North Carolina if there was more training available?
Certainly
Either through the
so.
center or otherwise?
Yeah,
Or some
definitely.
law school should be teaching it so that somebody could come out of law school being a legal plain language specialist. Would that help?
What a concept, the opposite
That's a
direction.
thought. I love
Yeah,
it.
wouldn't that be great? Would it also be helpful, Jennifer, and I'm going back to you because I'm going
Sure.
through the themes that I've heard you talk about, and Deanna, I'm coming to you next, and Laurie. You talked about the difficulties of taking legal jargon and making it understandable to the users that are not attorneys. I think sometimes attorneys don't understand the legal jargon also, so just throwing that out too. Would it be helpful if there were like guides that people could turn to that might be able to be used by different jurisdictions? Some of the same terms are the same, so if somebody could help distill those words and those terms into plain language in a booklet that all jurisdictions could use, would that be helpful?
Absolutely. And I'll tell you 2 reasons for that. First, and I'm thinking immediately, we spent so much time working on our domestic violence protective order guided interview, working through the language and how to phrase certain concepts as cleanly as possible. In other words, as straightforwardly as possible, but at the same time, really worrying that we might be setting a litigant up for a potential challenge at an appellate court if the actual questions they answered didn't involve the legal standard that is written out in the statute and the case law. And we could both have really benefited from being able to look and see easily what some other states have done and what best practices might have been. So that would have saved us a whole lot of time and conversation, but also having a national reference like the National Center for State Courts, for example, that had guidelines and could be viewed as an authority to make recommendations might have been something that would have made the powers that be feel more comfortable with perhaps being just a little bit more aggressive is the wrong word, but open-minded towards using some language that might not be quite so much copy paste from a statute, for example.
Mm-hmm. Well, I mean, this is slightly different, but the plain language community is about to promulgate standards for plain language. Then that might be a start to help all the courts, but certainly some standards for courts as well would be helpful. Cristina, do you want to weigh in on California before I move on to Washington?
Sure. I guess the only thing I would add is that, especially when we encounter these situations with rushes or anything like that, is that there's a tendency to say, especially when it's not institutionalized and there isn't a process of plain language created that everybody knows they have to follow, is that you'll rush, you'll fix the form saying later we'll come back to it. And then there is no later, right? Later, you're just adding more to it. And so then you have a form that started off at 5 pages. Now it's 10. It might be in a lot of plain language, but hand the litigant a 10-page, or God forbid, with our DV orders right now, 30 pages. If they actually delve into it, they'll see that it's easy to fill out. But how intimidating is it if you're in crisis and you get handed a packet that has 50 sheets on it and you don't, and you're not comfortable on a computer. So the only thing I'll add that it's not, I would challenge all of us, and I think it goes to a point that both Laurie and Jennifer brought up in terms of going other ways of thinking about plain language in terms of verbal or websites or whatever, is incorporating other tools. Because I think plain language, if we're thinking about just forms or written content, in and of itself is already becoming very inaccessible to a lot of people. And so what other tools that I think are part of the plain language ecosystem can we implement to help explain forms that we may be really constrained by, that we just may be stuck with certain things? How do we make this all the processes all along the way, written or otherwise, more accessible to everybody?
So I think
the bigger picture.
that Colorado may have hit on at least the beginnings of what is part of the ecosystem. I like the way you put that, the ecosystem of plain language. And it's not just language, it's also design and so forth and so on, but it's also how complicated is the process to begin with. So for example, like, you know, Penny just said, they eliminated the need for signatures on a bunch of forms, which is just like light bulb moment. You know, do we really have to have a verification? Do we really have to have this notarized? You know, I know that some states are beginning to look at that, but the processes that people have to, the hoops that they have to jump through, the simplification of processes also goes hand in hand. And sounds like Colorado has at least tackled the signature, which is a big thing for somebody to get something verified or notarized. It's a big thing if you're poor and you can't get it to a notary, or you can't pay even the notary fee. Or you can't find one in your community. You know, some communities don't have notaries. So is Washington or North Carolina, California worked on any of those kinds of simplification, you know, changing processes along with the plain language to, you know, they work hand in hand. Anybody want to weigh in on that?
I can tell you, I remember, and this again, it's also been a while, but in California, even just in family law cases, when you would file your summons and your complaint, you got the original summons returned to you. And then afterward, once your petition was served for the initial service of process, you would actually file it again. And that was so confusing because teleproper, this is an original, don't lose it. It's very, very important, bring it back, forget it, right? And so eventually that step got done away with. And so now you file your summons and your petition, and then you just serve a copy. So little things like that were caught as we had a task force, the Elkins task force, based on a Supreme Court case that worked on some simplification. There's a lot of room still to grow there, but there were little things like that ended up really making a huge difference. Or like having the proof of service on the back of a form that you are filing, but then they give it back to you, and then the litigant's like, you know, like, do I have an original? What do I have? And so taking little confusing steps out of that process is really helpful.
So Deanna, before I move on to Laurie and hear about the Washington process, because I'm somewhat familiar with Washington and they've done something very interesting there. Are there enough people in California that are part of the design by committee that have enough training and knowledge in plain language to really produce good plain language forms and instructions and signage?
I think it's fair to say that we could use a few more hands on deck. And I think that, you know, a lot of the training that we have received was at the behest of leadership that has now moved on. So we've had a shift in the folks who are really running our programs up, you know, at higher levels. And I think that, you know, it's probably time. We've had a lot of turnover in staff as well. So a lot of new faces. During the pandemic, we had, you know, and that continues to churn a little bit. So I think there's always a good opportunity to have more education. I think we would usually have conferences, and we would be able to go to see Maria or go talk to Cristina about plain language at one of those conferences. And we haven't had conferences. So, you know, I think we're sort of re-emerging after, you know, the pandemic. And I think there will be lots of good opportunities for us to get more education. And I think that can only help us.
Okay, so I think that what I'm hearing is that a ongoing formal training program accessible to all states and federal courts as well would go a long way to making a difference in the perfect world of plain language.
Absolutely.
So Washington, not last, what challenges did you face and are you still facing in terms of your current status?
I definitely echo the challenge of time. Just the amount of time that it takes to develop a good plain language form to make sure that it goes through the vetting to that it's legally accurate and that the legal community will have confidence in it. It's more time than anyone thinks it should take. And I think part of that, there's just sort of a discounting of how important it is and that it is a skill. And it's just so that it's like, the legislature passes a law, oh, and AOC will make a form, as if that's easy or quick. But it's really an important and time-consuming process. And so, I laughed, Penny, when I heard you say, 4 years. I mean, it took us 7 years to get our family law forms into plain language from the moment that we had a commitment from the Supreme Court and our Access to Justice Board, and everyone agreed it was a priority to actually publishing the first plain language form. It was 7 years. And part of that was, even with all the things we did right, and that we started off with actual plain language training from Maria and the team at Transcend, which helped so much and gave us so much energy and excitement around the process, and a shared vocabulary and vision of what our goal was. That was huge. So, and we looked at our whole library of just family law forms. It was over 200 forms, that had just grown organically over the years as, oh, somewhat, we need this, we need that. And, looking at what do we really need? What can we consolidate or cull from this list so that we're not overwhelming an unrepresented litigant choosing from 200 forms to figure out what they need to do. And then having an initial plain language draft of those forms, and sharing those with the legal community, with stakeholders, getting buy-in, making sure everything was legally accurate. That was this very painful drafting by committee process, but absolutely necessary in terms of getting buy-in from the legal community in accepting these plain language forms when they were in fact adopted and became mandatory for everyone. We had to we had a whole communication strategy. We had to basically did a roadshow of presentations at conferences and local bar associations to help the legal community understand what we were trying to do, have confidence in it, that it would be dignified, have integrity, that to get some acceptance in the few visual aids that we used with icons, the images. We had the same kind of knee-jerk reaction of, this is cartoonish, this doesn't look serious. People are paying, from the private attorneys who had to use these forms as well. You want somebody to pay me a couple $100 an hour to produce a form with a cartoon on it? I can't do that. And it was, and every time with this communication strategy and this roadshow that we did, it was really just trying to help the private attorneys realize that the audience for these courts or for these forms is the public. They're not for you. You're you're an intermediary in this process. It's the public and the litigants who actually have to live with these forms, follow the orders that are entered, and put the important information about their lives on these forms so courts can make good decisions. And so we really had to just have a drumbeat of message that these forms are for the public, and that's why that this tone is appropriate, and that's why these images are appropriate. And we didn't get everything we wanted, right? We made some concessions, but it's been nice to see, as once the forms did become mandatory, which happened for Washington in 2016, the sky did not fall. People actually found the forms quite useful. People realized that the forms were legally accurate and did tick all the necessary statutory boxes. And because they were organized clearly, they helped the judicial officers make complete findings and address all the issues. So it's with all the anxiety and the difficulty that led up to the adoption, the utilization has been very satisfying. And that's what's let us then move on to other areas of law and improve those forms step by step.
So let's talk about a population, part of the system that may or may not be a problem in your jurisdiction, and that is judges. Did you have problems with your judges embracing plain language? Did you get the leadership that you needed? And did leadership make a difference in your jurisdiction in terms of getting you to the point that you're in now? So we know that the bar has had problems with plain language for various reasons. I had one lawyer said to me, well, they should go to law school. I'm like, well, not everybody can go to law school, sir. But anyway, what was your experience, Laurie, in Washington with judges, both, frontline judges and leadership judges? And did it make a difference?
It made a huge difference. And for the most part, the judicial officers in Washington were extremely supportive. And it certainly helped that we had strong and vocal support from our Supreme Court, and that helped us. That trickled down, and they wrote a letter in support. The Supreme Court wrote a unanimous letter in support of the project, which was being led by the ATJ community outside of the court system. So it was necessary and helpful to have that endorsement from the Supreme Court that this was important and it was a good idea and it was going to be done well and it was going to be done responsibly. And we absolutely shopped that letter around and showed it everywhere that we were presenting and asking for feedback on the forums. So that top level support was super helpful for us, but also the trial judges and especially the family court judges that were seeing all these unrepresented people were almost unanimously supportive and helpful, because they knew that it wasn't all lawyers appearing before them with, well-prepared, typed and complete forms. They were seeing the problem firsthand. And so we found our judicial officers to be very supportive and helpful of the process and gave us helpful comments as well. And we had judicial officers that spent most of those 7 years with us. Some of them met with me weekly to look at the forms line by line, because they did recognize how important it is and what a difference it would make to their ability to manage their courtrooms.
So Jennifer, did you get judge buy-in, both leadership judges and frontline judges? And what's going on in North Carolina with judges?
Yeah, for our work, we were really tied in so closely with the e-filing system that our leadership buy-in was really important. And it was viewed as a way to begin that process with a success and really focusing on the court users. And so that was great. I mean, it's all part of the move towards, and I emphasize towards, not there, but towards more paperless. I think going all the way paperless is not going to happen, but closer to a paperless system. And so the plain language fits in really nicely with that effort. And that's certainly supported by leadership.
Penny?
Interestingly enough, so one of our pilot courts, the chief judge was our champion through the whole process. And one of the things he said early on, we would meet with him regularly and work on the forms and so
Can I
on.
interrupt you? Is that the chief judge of Colorado or the chief judge of a particular court?
It was a chief judge of one of our districts.
Okay.
And it was one of our rural districts, actually. And we would meet regularly and work on the forms, and then he would vet them through his judges, and was extremely, extremely helpful. And he said early on, he said, when people come before me on the bench, when I'm on the bench, he said, I talk to them in plain language. Why would I not want them to be able to understand what it is I need from them in plain language? And that really resonated. And so He worked very, very closely, very well with us, but we did have a couple judges, and I will say just a couple judges that were very vocal in not having plain language. You know, I can't tell you how many times I heard in different situations, well, plain language is dumbing down the integrity of the court, and we're not going to do it. So that was a real barrier, you know, to overcome. But as a result of our legal team not participating, but a team of judges from within a district helping us, that really went a long way. And this chief judge was then able to go to the Chief Judge's Council and describe to them, you know, what we were doing and how valid it was. And we piloted in the area of family court forms. We just did 14, but we kept statistics and so on and so forth. And we determined that there was a 30% savings in time, not only with court staff, but from the bench. And the judges were able to make, you know, very clear rulings and orders, so the parties understood them and were able to comply, you know, more than they had in the past. So it was really an interesting process.
So in California, did judges make a difference in terms of moving you to where the point you are now?
I think similarly to what some of the other states have reflected, judges are on the front line. So they are really vested in making sure that the people coming before them understand what they're doing there, what the purpose of the entire hearing is. They want to be able to open the form that's been filled out, go exactly to where they want to find the information that they need to make a decision. So I've found judges personally to be some of the biggest supporters of the work that we're doing. And I don't really, maybe Cristina has a, you know, because of her longer view, has some recollection of a judge that might have been, you know, opposed. But I can't think of judges. I would say that the one constituency that I think gets overlooked a lot and that can sometimes really be challenged by some of the plain language are the clerks. So I call them our forgotten customer. And because I work for a court system, I have to keep them in mind. I can't only think of an SRL or only think of a judge or only, you know, I have to think of all the different people who are coming in contact with a form. And just as an example, you know, if we want to take take a form and take away the words plaintiff and defendant, petitioner, respondent, and try to go plainer with that, that can be a challenge for when that form comes in front of a clerk, because they have specific things that they need to enter, to log about a case in order to set up a case name and a number and assign it and put it into their system. And so it's just a group of folks that we always need to make sure that we are in contact with and considering their needs as well.
Okay, great. Great. So we are somewhat winding down on time, but let's end on a positive note, and then I would like to try to summarize some of the themes that came out of our discussion. What was the best thing you did in your jurisdiction to get you where you are today? One or two things. What's the best thing you did in Colorado?
I think when we first started, we formed a group with a lot of different stakeholders, like we have talked about. We had judges, we had clerks of court, we had private attorneys, legal aid attorneys, our Sherlocks, our self-represented litigant coordinators, family court facilitators, and users. And that, I think, really got us off on a really good start. We also had a professor, Judge Fisher, you've talked about law schools. We have a professor from DU Law School that partners with us, and she has from the very beginning. And she teaches plain language and is a plain language expert. So we are very fortunate to have her as part of our collective group. So I think that was one of the best things that we did to get off the ground and to have such a diverse group able to face, you know, some of the challenges that we did from different perspectives.
Well, I think the rest of the jurisdictions would like to borrow that professor.
I'll loan her to you.
Okay. And might I also add that, you know, I am a law professor now, I'm not actually a sitting judge anymore, is that I see resistance within the law school community about teaching lawyers to use plain language, and it trickles down into practice. I mean, you have to communicate with your clients, so shouldn't lawyers be using plain language when they're communicating with their clients, communicating with the court, but also clearly for unrepresented litigants? And one of my very, very close friends that I went to law school with says, you know, you're just trying to dumb down the law. You can't dumb down the law. And so, you know, she and I will never agree on that issue. So maybe some focus on law school education and what we teach our lawyers might be really important. Deanna, what are one of the two best things that California has done so far to advance towards a perfect plain language environment?
Well, I would say that number one would be we brought in Maria. And she was able to, we knew that we needed an expert. So I guess that's to our credit that we couldn't do this on our own. As Jennifer's mentioned, lawyers are not natural plain language writers. It doesn't come naturally. And to your point, Judge Fisher, I think that, the academy is one of the last sort of hurdles that we have to get, some understanding of what is necessary now in modern legal practice to be able to communicate with your clients, to be able to navigate the courts and to understand the value of plain language. I'm with you 100% there. And I think there's still resistance in those circles. But yes, we knew to bring in an expert, and we were fortunate to have Maria in our community here and to be able to bring just the education, to bring the work on the forms themselves and on the content itself. And then to sort of lead by example and to help bring us all along. And that also fed into our translation efforts. And so I feel like that was really the biggest positive and the most important thing we did. And that was also because of, leadership interest in this, that we were able to do that.
Great. Well, Hofstra Law School, which is where I teach, did a plain language conference right before the pandemic. And some of the recommendations that came out of that conference is that perhaps plain language education should be part of the CLE requirements for lawyers. And that because right now we have to do ethics and skill training, right. And now diversity. Why not make plain language a CLE requirement? Offer plain language courses at the law school, but also at the undergraduate school as well, because you could, use people who are not lawyers, and we should be using non-lawyers as, I hate the word non-lawyers, but people who are not lawyers to actually help in the plain language movement. So that's something to think about. Yeah. Jennifer, what are the two best things that North Carolina did to get you to the point where you are now? We know that we have far to go, but to get to the point that you're at now, what are the two best things that North Carolina did, or one thing?
I'm really excited about the work that we have done on plain language so far. Again, as you say, plenty to grow, but there's so far, I think two things I would point to. The first is really just targeting areas that are most critically needed by court users, just to have the biggest bang for our buck, if you will. And some of that is testing what we thought we knew versus what we actually knew. And I think that's a trend that you can sort of see mirrored in a lot of the comments so far. So for example, when we were looking at our first document generation area to focus on, we looked at the search results on the court website, and divorce was both the #1 and the #2 frequently searched term. One was capitalized and one was lowercase. And so that was 100% going to be part of what we did. The other thing that I'll say that I'm really proud of is in thinking about user testing, it's something we wanted to do and we're trying to figure out our best approach. And actually in consultation with Maria, after working on our plain language efforts to bring it, as a first round to actually validate and test the plain language, we ended up backing up our results that we had prepared with her through a set of user testing that actually took, we used eye tracking technology, which actually brought people into a room and then set up a neat little bar at the top of the computer that watched their eyeballs and recorded where on the page they were spending time looking. And so that kind of scientific data and so common sensey science, if you will, right? Where people could literally see what folks were doing rather than actually just hearing you summarize it, was really a great way to underscore some of the lessons that I think, you know, many of us probably know already about design, although we did find some real surprises when we tested what we thought we knew and how it actually played on the ground. For example, and I won't go too long on this because I know we're short for time, but we had, in one of our efforts to eliminate clutter on the page while still sharing some kind of backup supporting information, we had hidden some definitions or some additional information behind an eye icon that was there and clickable to bring up a little pop-up with a definition or something, which seems like very logical. In the course of our study, not a single person voluntarily clicked on an eye icon. So if we hid what was really critical information back there, people were missing it. And if nothing more, it wasn't a useful way to provide supporting information to people, at least in that version. And so again, in a perfect world, we could iterate on that more and try a different icon and see how that went. But that was a complete surprise to us through this system. And there's much more I could say about that, but the diversity of people that we used in that tracking technology test was really important. We used geographically diverse, ethnically diverse, age diverse, education diverse, so that we really could say this was not just a certain type of person that had this response, but was really ranged across the entire court user population.
Great. Laurie, what are the 1 and 2 best things that Washington did to get you to the point you are now in the plain language environment?
Well, I have to echo that. I think the first best thing that we did was engage with Transcend, and they came and did a 2-day in-person, I mean, back in the day, in-person training, but all of our court staff and a lot of the volunteers on the court forms committees came to this, and judges came to this, clerks came to this, and it was such an aha moment for all of us, in both in realizing how hard plain language is and what a real skill it takes, but also how different it can be. And it was really inspiring and got it and helped people commit to the goal and to making it happen. It just supercharged the whole project. So that was the first best thing. And the next best thing I think that we did was that we staffed it. We actually, it's simple, but we staffed it. We had committed professional time to the project, and that helped carry it through and make sure that things really got done and completed in a consistent way.
Great. Cristina, do you want to weigh in at all? I know you're in a slightly different.
Yeah, I'll just add, because I second what everybody else has said. I'll just add that even if you start really slow, but you put a plain language form out there and the sky doesn't fall, it's a good lesson that maybe this isn't really so bad. So because in California, I think, you know, at first everybody was like, oh my God, what's happening? And then I think maybe it was small claims might have been one of the first forms. I think it's a really high stakes type of case, but it's not seen as very high stakes. And nothing happened. Everybody was able to fill out the forms with fewer questions, and judges had all the information. And so I think that was, you know, a really important sort of step to kind of get people to continue to buy into that process.
Okay, so let me try to kind of pull some of our themes together and sort of summarize today's talk. I think it starts with all of us knowing and understanding that users have to have trust and confidence in the court system. And trust and confidence in the court system starts with the court system being fair, and you can't be fair unless you are communicating clearly and plainly to the users that use the court system. That is not just about trust and confidence, but that if you use plain language correctly, it could also be extremely cost saving for the court system and might make it just, you know, less painful for the courts, the judges, and for the users as well. that we have to move towards embracing that we have to address the needs of users, not just attorneys. And that in doing that, we have to approach things with tolerance and empathy, and less judgmental kind of things, so that in order to make sure that we are meeting the needs of users, that we need to do testing of forms, use science, which North Carolina did, to figure out how users are responding to the form, and that we need to engage a diverse community in terms of making sure that what we do in plain language meets the need of the whole and not just to a small part of the population. That we can't just be in a silo as a court system or a justice system, that we have to actually look to our legislatures to draft laws that are plainly stated, so that it's easier for the courts and legal aid and users to draft forms. That we need training in both oral and written plain language. We need staffing. We need the resources for us to be able to do plain language properly, and that staffing should not be just limited to lawyers that work in the court system or the justice system, but to people who are not lawyers as well, that they can add to the plain language environment just as much as lawyers can. We must enlist our judges both from a leadership level, but also a frontline level, to make sure that we move our ball towards a perfect plain language environment. And that includes not just forms and signage and instructions, but I also would like to see the judicial part of the system move towards doing plain language decisions as well. We didn't get a chance to talk about that. That's my own 2 cents. A simplification of processes would also help with going a long way towards helping with doing plain language as well. And that we all agree that standards would be helpful. And sort of like a national training program on standards and plain language would be helpful, and maybe a legal jargon handbook booklet that all jurisdictions could use would be also helpful. I think I sort of captured everything that we talked about, which was quite a bit for the last hour and a half. Is there anything that I missed that you'd like to add to this?
I just want to put a plug in, because I work a lot on translation, that for all of us who are trying to do multilingual access, that plain language makes translation much easier and much more effective.
Exactly. And you think of the double layer of complication of someone who is trying to deal with legal terms that don't make any sense in English, but that it doesn't make any sense in the second language as well. So that is essential. And our population of users is getting more and more diverse as we speak. So that's essential. Thank you, Cristina, for weighing in on that. I didn't mean to overlook that. For those of you who are fortunate enough to be able to do a RFQ or RFP to bring in a specialist, there are people out there that can help you, draft the right one so that you get the right people. And I think I didn't also add to that we need to put pressure on our law schools to do more plain language training so that we have more people who are, able to do plain language, and that we need to figure out how to create more plain language specialists in this country so that we don't all have to fight over Maria and Transcend and so forth and so on. And we love the specialists that we do have, but we do need more specialists out there. So we need some kind of certification program here in the United States, so people don't have to run to Canada just to take the one course that is available here in North America. So with that said, I want to thank all of you for not only being here today to talk about this, but also to be part of the movement towards the perfect environment for plain language. It is a long journey. We will get there. It's a step by step, as Cristina said. You got to take the small steps. You got to put your toe in to the water, and then you can dive in at some point. But it starts with that toe in the water, that first step. So good luck to all of you in the jurisdictions that are here today on the panel with moving the ball forward towards that 5. And for those of you who are viewing, if you're down at 1, you can get to the 2.5, and eventually we'll all get to 0.5 if we work on this together. Thank you so much.